It is 11:43 at night. You are in bed. You hear something outside, a car door, footsteps on gravel, then silence. You reach for the nightstand. Your hand finds the grip of the firearm you have kept there for over 20 years. You do not panic. You breathe. You wait. Nothing happens. It was probably nothing. It almost always is. But you sleep better knowing it is there. You always have. Now imagine this. 2 weeks later, your daughter calls. She sounds nervous. She says, "Mom, I saw on the news, they passed new gun laws. I think you have to re-register. I think you have to take a course. I think you might have to turn it in." And you, because you trust her, because you do not want to break a law by accident, because you have lived your whole life doing the right thing, you start to believe her. You start to wonder if the firearm in your nightstand, the one you have owned legally for over 2 decades, has somehow become a problem. That moment, that quiet surrender of something you earned, something you own, something the Constitution protects, is exactly what this video is about. Because what your daughter told you may be completely wrong. Not because she was lying, because nobody told her the full picture. And nobody told you. Here is a question I want you to answer in the comments before you watch another second of this video. Do you believe that states have the right to impose new carrying requirements on seniors who have already held valid permits for years, or do you believe that existing permit holders should be permanently grandfathered under the rules they originally qualified under? Drop your answer right now before we go any further. I want to know where you stand before I give you what the courts have actually said. Now let me bring you up to speed on what actually happened, because the story is more specific, more protective, and more powerful than almost anything you have read or heard about these new laws. This is not a single new law. This is not one piece of legislation passed in one state last month. What is happening across this country right now is a sustained wave of state-level gun regulation that has been building for several years, and it is landing hardest on the people least equipped to navigate it. Since 2022, dozens of states have passed new carrying permit structures, mandatory training requirements, re-qualification timelines, increased fees, and age-based capacity restrictions. The coverage of every one of those laws follows the same pattern. Here is what changed, here is what you must do now. What that coverage almost never includes, the part that a responsible legal analysis demands, is this: here is who is specifically exempted, and that omission is costing legal gun owners their rights every single day. To understand why these exemptions exist and why they are legally durable, you need to understand the constitutional chain that created them. In 2008, the Supreme Court decided District of Columbia versus Heller. That unanimous 9-0 ruling established for the first time as a matter of federal constitutional law that the Second Amendment protects an individual's right to keep a firearm in the home for self-defense. Not a militia right, an individual right. That ruling changed everything. In 2010, McDonald versus City of Chicago extended Heller to the states. Before McDonald, the Second Amendment only constrained the federal government. After McDonald, it constrained every state legislature, every city council, and every county ordinance in the country. Then in 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin. That ruling struck down New York's may issue concealed carry permitting regime and established a new constitutional test, the historical tradition test. Under Bruin, a gun regulation is only constitutional if the government can show it is consistent with the historical tradition of firearm regulation in this country. That standard has reshaped how every circuit court in the country evaluates new gun laws. And this is where the story gets very specific, because the Bruin framework is exactly the legal foundation that makes senior exemptions not just good policy, but constitutionally required in many circumstances. After Bruin, federal courts across the country began applying the historical tradition test to pending and newly passed gun laws. The results have been striking. The Ninth Circuit, covering California, Arizona, Nevada, Hawaii, and several other western states, has seen a torrent of Second Amendment challenges since 2022. The Fourth Circuit, covering Maryland, Virginia, North Carolina, South Carolina, and West Virginia, has also seen significant litigation around training mandates, permit fees, and re-qualification requirements. The Seventh Circuit, covering Illinois, Indiana, and Wisconsin, has addressed similar challenges involving the burden these requirements place on specific classes of gun owners. In multiple cases, courts have scrutinized whether mandatory training requirements, especially physical range qualification components, survive the historical tradition test when applied to older Americans with documented physical limitations. The historical record does not show that the founding generation required elderly citizens with mobility limitations to pass physical fitness tests before exercising their right to keep arms. That absence of historical precedent matters enormously under the Bruin framework. But before you jump to conclusions, let me give you the other side of this argument. Because a responsible legal analysis has to. There are serious, principled legal scholars and courts that have argued states retain substantial authority to regulate the manner in which firearms are carried in public spaces. The argument goes that Bruin addressed the threshold question of whether a permit system is constitutional. Not every condition a state may attach to the permitting process. Under this view, reasonable training requirements ensure that people who carry firearms in public are actually competent to do so safely, and that serves a legitimate public interest that courts should respect. Some circuits have credited versions of this argument in upholding training requirements that are reasonably tailored and not prohibitively burdensome. That is a real argument. It is not without legal merit, but here is why the weight of precedent favors a more protective reading for senior gun owners specifically. The Supreme Court in Bruin was explicit: the government bears the burden of justifying every regulation. When that regulation disproportionately burdens a class of citizens who have already demonstrated lawful compliance for years or decades, and when the historical record does not support that specific burden, courts have consistently found constitutional problems. Senior-specific exemptions are the legislature's recognition of exactly that legal reality. Let me break this down by where you live, because your state's category determines what these new laws actually mean for you. If you live in one of the 29 constitutional carry states, states like Texas, Florida, Arizona, Tennessee, Georgia, and Montana, you already live in a jurisdiction where permitless carry is legal for most adults. In these states, the new requirements are often limited to optional enhanced permit programs, and age-based exemptions are frequently written into those optional structures. If you are a senior in a constitutional carry state, your baseline right to carry without a permit is largely untouched by these new laws. Your focus should be on understanding whether any new enhanced permit requirements affect benefits you currently receive, such as reciprocity in other states, and whether any grandfather clause protects your existing permit status. If you live in a shall-issue state, a state that must issue a permit if you meet the objective legal requirements, the new laws are more likely to have changed your renewal process. These states include Ohio, Pennsylvania, Colorado, and others. In shall-issue states, age-based exemptions and grandfather clauses are your primary tools. Many of these states have written explicit carve-outs for permit holders above 65 who have maintained continuous permit status for 10 years or more. If you live in a restrictive may-issue or heavily regulated state, California, New York, New Jersey, Maryland, Hawaii, or Massachusetts, the legal landscape is the most complex and the exemptions are the most critical to understand individually. Now here is the exact phrase I want you to write down. If you are ever at a permit renewal office, speaking with a law enforcement officer, or on the phone with a state licensing authority, and they tell you that you are subject to a new requirement you did not previously face, say these words clearly and calmly. I would like to know specifically whether a senior permit holder exemption, a grandfather clause, or an ADA accommodation process applies to my situation. Please provide that in writing before I take any further action. Say it once. Then stop talking. Wait for the written response. Do not surrender anything, do not sign anything, and do not waive any right before you have that answer in your hand. If you want to stay ahead of these rulings as they happen, go ahead and hit subscribe. I am tracking every case so you do not have to read the legal jargon yourself. This area of law is moving fast, and the decisions coming out of the circuits over the next 6 to 12 months will significantly shape what states can and cannot do to senior gun owners. Here is what legal analysts are projecting. The Supreme Court's decision in United States versus Rahimi in 2024 addressed the constitutionality of disarming individuals subject to domestic violence restraining orders. While that case was specific to a different fact pattern, the majority opinion clarified how lower courts should apply the historical tradition test from Bruin, and it has given some circuit courts more room to uphold certain narrowly tailored restrictions. The practical effect for seniors is that broadly applied training mandates with no accommodation process are likely to continue facing successful challenges, while narrowly tailored requirements with robust exemption frameworks are more likely to survive. Legislative backlash in heavily regulated states is also coming. California, New York, and New Jersey have each signaled legislative intent to add additional requirements in response to court rulings, a pattern that legal scholars call regulatory whack-a-mole. Every time a court strikes a requirement down, the legislature drafts a variation designed to survive the next challenge. For senior gun owners, this means the exemption landscape will continue to shift, and the importance of staying current on your specific state's code cannot be overstated. Now, I need to address a specific misconception that is spreading widely. If you see anyone claiming that the courts have ended all gun laws, that is factually incorrect. Let me explain exactly what did and did not change. Bruin did not eliminate the ability of states to regulate firearms. It changed the standard by which those regulations are evaluated. Background check requirements, prohibitions on certain classes of individuals, and many other long-standing regulatory structures remained fully intact. What Bruin challenged and continues to challenge are regulations that cannot be grounded in historical tradition, and that challenge is ongoing, not concluded. Understanding that distinction is what separates informed gun owners from people who either panic unnecessarily or remain uninformed until it is too late. Here is what you do right now. Today, not this weekend, not next week. Pull out your carry permit and check the expiration date. If it expires within the next 6 months, begin the renewal process immediately, before you fully understand the new requirements, before you know whether an exemption applies to you, before anything else. Continuity of your permit is the single most important protection you have, and it only works if you do not let it lapse. Second, go to your state attorney general's official website and search for your state's carry permit statute. You are looking for language about age-based exemptions, grandfather clauses for long-term permit holders, or hardship waiver provisions for permit fees. If you cannot find it yourself, call a licensed gun rights attorney in your state, not a gun store, not a police non-emergency line, an attorney. Third, if you have a documented disability, mobility limitation, or physical condition that would make standard range qualification unreasonably burdensome, speak with an attorney before your next renewal about the Americans with Disabilities Act accommodation process. That process must be initiated formally and in writing. It does not happen automatically. Fourth, remember the distinction that the Supreme Court drew in Heller. Your right to keep a firearm in your home for self-defense is a separate constitutional protection from your right to carry in public. New carrying laws do not touch home storage rights. If you do not carry publicly and have no intention of doing so, the bulk of these new requirements may be legally irrelevant to your situation. I am a legal analyst and content creator. I am not your attorney. Laws vary by state, and this video does not constitute legal advice. Consult a licensed attorney in your jurisdiction before making any decision about your firearms or permit status. Now let me bring this full circle. At the beginning of this video, I asked you, do you believe states have the right to impose new carrying requirements on seniors who have already held valid permits for years? Or do you believe that existing permit holders should be permanently grandfathered? After everything we have walked through today, the Bruin framework, the ADA accommodation right, the grandfather clause mechanics, the distinction between carry rights and home rights, has your answer changed? Drop your updated thoughts in the comments. I genuinely want to know. In the next breakdown, I will be covering what your rights actually are when law enforcement comes to your door and asks to inspect or confiscate a firearm. That scenario is happening more than you think, and the words you say in those first 30 seconds determine everything that follows. Stay safe, stay informed, and know your rights before the ruling, not after.